time for our panel discussion, Human Rights in the 21st Century, Challenges and Opportunities, and you've got some great speakers here this afternoon. I know a lot of you probably know several of them. You may know several of them quite well, but I'm going to introduce them to you anyway, because I know that for some people they're not as familiar. I'll start with Graeme Innes, to my left. Graeme is a lawyer with 30 years' experience as a practitioner of human rights. He's been Australia's Disability Discrimination Commissioner since 2005. During that time, he's also served as Australia's Human Rights Commissioner and as Race Discrimination Commissioner. He's led or contributed to many initiatives, including the Same-Sex, Same Entitlements Inquiry, drafting of the UN Convention on the Rights of Persons with Disabilities and its ratification by Australia, and the development of a national disability strategy, among many other things. Graeme has served also on numerous tribunals. He was the first chair of Vision Australia and the chair of the Disability Advisory Council of Australia. Claire Mallinson. Now, I know you all think you know Claire, and I think I know Claire too, but reading her CV, I found out things about Claire that I didn't know, and I think we should all know and appreciate our Claire more. Claire, of course, has been the National Amnesty, National Director of Amnesty International since 2007. She has a degree in economics, politics and sociology and 26 years of experience in rights-based work and the not-for-profit sector. She began her work at the UK's biggest not-for-profit disability organisation, Scope. She went on to become the youngest director of a UK top 5 charity, the Cancer Research Campaign. Claire was part of the team responsible for the largest not-for-profit merger in the world. 5 years after the merger, Cancer Research UK's annual research spend had doubled and annual income had grown to £468 million. Claire moved to Australia in 2003 to become Director of Fundraising and Marketing for Greenpeace Australia Pacific. At Amnesty International Australia, Claire is committed to enabling people from all walks of life to participate effectively in the international human rights movement and to seeing that movement continue to grow. We're delighted that she's at the helm, and Claire, in fact, is going to moderate this session this afternoon. George Williams is one of Australia's leading constitutional lawyers, as we all know. He's also a leading reviewer of sci-fi novels, which you may not all know. He's a leading commentator on both legal affairs and human rights. He's Anthony Mason Professor at the University of New South Wales, where he founded the Gilbert and Tobin Centre of Public Law. He led the Victorian Human Rights consultation that resulted in the enactment of Victoria's Charter of Human Rights, and he's currently engaged... Yes, indeed. He's currently engaged in a 5-year international project on anti-terror laws and democracy, and I hope we'll hear something about that this afternoon. Stephen Keim has been a barrister for 26 years. He's president of Australian Lawyers for Human Rights, and he was president of the Queensland Council for Civil Liberties in the early 90s. In 2007, he represented Dr. Mohammed Hanif, who was wrongly arrested on terrorism charges. Dr. Hanif, of course, was subsequently totally cleared by the Clark inquiry. I'm glad that wasn't my mobile phone. Stephen had famously leaked to the Australian newspaper a 142-page record of interview of Dr. Hanif, conducted by the Federal Police, so that journalists and the public could see the actual evidence on which the government action was being taken against his client. His courage, given the associated risks involved for him, won't be forgotten, and was acknowledged in 2009 by the Australian Human Rights Commission, which awarded Stephen the Human Rights Medal. And Widney, of course, you met earlier. She gave that brilliant talk. But I'll introduce Widney again for those of you that weren't here during that session, with apologies for those of you that have heard me say all this before about Widney. But she is, of course, the Senior Director of International Law and Policy at the International Secretariat of Amnesty International. She participates in legal standard-setting negotiations at the regional and international level, and designs the strategic framework for Amnesty International's global campaigns. And prior to joining Amnesty, she worked for 9 years at Human Rights Watch, and she has also been a lecturer at Yale in health and human rights. So, enjoy the session. Over to Claire Mallinson.
Thanks, Mary. And as Mary's outlined, we have a stellar panel for you this afternoon. So, although this is normally the dead slot at any conference, because you're all fated with good food and probably because of the rain didn't get any exercise, I don't expect any nodding off. In fact, if I see any nodding off, we will put a mic in front of you. So that, despite having this bright light on us, we will keep our beady eyes on you. We're going to start with George, who's going to excite us about the Constitution. Now, George has up to 15 minutes on this, and at the 12-minute mark, we'll get a ping from me, because I know that occasionally lawyers do like to talk, I've heard. So we will go through all 4 speakers, and then we're going to open up to questions, and if they are as good questions as we had this morning, I know we're going to have a really stimulating afternoon. So, George, over to you.
Well, thank you very much for that generous introduction. I would say that I suspect asking me to talk about the Constitution will run counter to that purpose of not making this a dead slot, but I will see how I go. I'm reminded in nodding off that one of our High Court judges, Lionel Murphy, used to keep a copy of the Constitution by his bedside. He was an insomniac, and he said he never found a better remedy for insomnia than the Australian Constitution. So again, I may be in the wrong session, but I'll see how I go. I do want to acknowledge the traditional owners, and also to acknowledge how much of a pleasure it is to talk at this Amnesty 50th anniversary conference. And I do so not just as someone who's been a member of Amnesty for many years, but actually because my memories of Amnesty go back to when I was a very young boy. When I was 5 or 6, I remember helping my mother write letters about prisoners of conscience. In fact, my mother taught me to write by writing some of those letters as an Amnesty member a very long time ago. So my memories of this organisation, I'm sad to say personally, go back to the 1970s, but a lot of my own values were formed by writing those letters, and in doing so, my own strong views about the role of human rights and the role, particularly I think young children should be playing in understanding values about fairness and equality within our system. That said, it's time to turn to the Australian Constitution. There are 2 ways of looking at Australia's Constitution and its contribution to human rights, and you can look at what I call the dominant way in Australia, and that's a view that was put particularly well by Sir Robert Menzies, our longest-serving Prime Minister. He said, when it comes to the Constitution and our legal system, and I quote, "The rights of individuals in Australia are as adequately protected as they are in any other place in the world." Now, that sort of statement has a very contemporary resonance in Australia. You can look at, say, in early 2000, Prime Minister John Howard, in discussing mandatory sentencing in the Northern Territory, that regime that led to unparalleled rates of incarceration of Aboriginal people. He said in response to attacks on that system that Australia's record and reputation when it comes to human rights and, again, the role of our Constitution is quite magnificent. And, of course, you can see resonances again today. You only need to look at the Rudd-Gillard governments. The Rudd government rejected a National Human Rights Act on the basis that we didn't need further human rights protection, that the Constitution does a good enough job in this respect, as does our legislation, and so we simply didn't need better human rights protection in this country. And more recently, you can find, say, Prime Minister Julia Gillard in countries like China, proudly extolling Australia's human rights record and feeling very confident, given that record, and willing to take on China for its record on the basis that no apparent changes are needed to the Australian legal system. Now, I'd have to recognise that this is the commonly held view in Australia. It's held because people do believe we have a great system of legal protection for human rights. And I'd say that, in part, that's a fair reflection. We've got a lot to be proud of in this country. particularly around our political freedoms, and we do need to recognise the many achievements of Australia in this regard. But it also reflects an Amnesty survey taken a few years ago that asked Australians, do we have a National Bill of Rights? And 62% said yes. So we're dealing here with a commonly held view, which is actually based upon a level of false information. And I've just run into this on many, many occasions where Australians think we've got a Bill of Rights, and they do believe that we have a great legal system because if nothing else, so if they're in court, they can take the fifth. That's the one that tends to come up very often. I've seen that personally on a number of occasions. And when it comes to human rights education, we need really to recognise the tremendous contribution made by Law and Order, CSI and a range of other US cop shows to the Australian system of human rights education. But that tells you, I think, a lot about the state of human rights protection in this country, that it's based in large part for the majority of the population upon a misunderstanding of the system. Well, that's the dominant view, but I think, of course, there is a different view, and that different view is really born out of looking at our constitution and legal system through an entirely different set of eyes. And I would say not my eyes, not the eyes of someone who is privileged within our system, someone who is white and middle class and doesn't have much to fear from our system when it comes to anti-terror laws or other problems, but in fact through the eyes of people who often get a raw deal in our system. Often asylum seekers, Aboriginal people or others who actually get the bad end of the stick when it comes to our legal system. When you look through their eyes and you look at our constitution, you recognise that the role of a constitution as a basic legal document is to provide protection to those type of people, not just to establish what governments can do, but also establish the limits of what governments can do, and to ensure that governments must operate against a reference that their powers are tempered by a respect for the dignity of the individual, by a respect for human rights such as free speech and a range of other very basic human rights. But that's where our system of law and justice breaks down at the constitutional level. We do not have in this country the most basic checks and balances that you find in most other countries that do temper the exercise of power on behalf of the people. You've got a few scattered rights. We've got a trial by jury in the Constitution, but the High Court has said that only applies where the Parliament says there needs to be a trial by jury. There's nothing there about freedom of speech, and indeed no case on human rights grounds under the Constitution dealing with these type of rights was even won until 1989. So it took 88 years to even win a case, and that was one dealing with the rights of lawyers to practice interstate. Of undoubted profound importance, but nonetheless, we have not had human rights cases and victories under the Constitution in this country, with only rare exceptions. What it means is we have a system where we have the basic protections missing. And again, this wouldn't necessarily be a problem if we had the conventions of our system, if we had a respect for human rights in the political process that meant that the protections didn't need to be engaged. But we all in this room know that that's far from the case. And the absence of those protections is especially telling when it comes to particular groups within the community. And I'll raise a couple of those, but let's just start with the position of asylum seekers coming to this country, fleeing persecution, seeking a fair hearing for their claim to protection. They're the sort of people in other countries that you would expect a constitution would require protection against arbitrary detention, particular protection perhaps for the rights of children, protection for rights to a fair hearing and to natural justice. But our constitution does none of those things, and indeed it is what has enabled the laws that we have in this country that in key respects go further and are in a worse state than you find in other countries. To be quite specific about this, we had a number of challenges about these issues in 2004. 3 cases raised these questions on constitutional grounds. In the first, in a case called Woolley, it was argued that you can't detain children, unaccompanied children, under Australia's legal system, and the High Court said no, there's nothing to stop that happening. The second case of Barroos, it was argued that, well, you can't detain these people in harsh and inhumane circumstances. Surely there's something protecting against that, and the High Court said no. Again, there's nothing written into our system to stop that. And in the third case of Alcatab, again in 2004, it was argued, well, surely that can't be indefinite. There's got to be some limit to this detention, and the High Court again said no. Indefinite detention of asylum seekers is permissible under Australia's constitution, and in that case the judges specifically referred to the fact that other countries had decided the same case the other way, but they said those countries have a Bill of Rights in their constitution, and that mandates a different outcome. Put those things together, we have a legal system that permits the detention of children in harsh and inhumane circumstances indefinitely. And that is not a trilogy of outcomes that can be achieved in any other comparable democratic country in the way that has occurred in Australia. And that happens because there's nothing in our constitution that says that's not a permissible set of outcomes. You can also add the recent Malaysian experience, the bill that's in Parliament at the moment that's about to be debated next week. That bill is remarkable. It strips people of their natural justice absolutely explicitly. You don't tend to find that in Australia, even with the human rights violations. Normally it's done more by sleight of hand and less being direct about these things, but that bill just strips away natural justice directly and enables the removal of asylum seekers to another country without any consideration whatsoever needing to be given to the welfare of the people being removed. That's explicitly done away with as a consideration. And again, that's quite remarkable to find that you don't need to even pay lip service to the welfare of these people. It's actually hard, I think, looking at this bill to think of a more fundamental abrogation of our human rights responsibilities to people in need of compassion. And certainly as a lawyer, I think it shreds any pretense of even seeking to comply with the International Refugees Convention. The bill may not be passed, but it says a bit about the state of human rights protection in Australia, that if it's not passed, it's simply because our major parties can't agree on quite how to abrogate human rights. And there's disagreement about the nature of that abrogation, but really let's not kid ourselves that it's got to do with any fundamental desire to protect human rights. These things say a lot about our legal system, and they say a lot about our constitution. I want to finish with the second example of Aboriginal Australians, because here there's also an opportunity, which is a very rare one in our political and legal system. Our constitution has often been said to have failed Aboriginal people, and that's certainly true. It enabled them to be denied a vote until 1962. For most of the life of our nation, Aboriginal people have not voted in our federal elections, and that indeed was not just a failure, but the Constitution was designed to enable that failure. It was actually designed to permit racial discrimination in key respects, and there's no doubt about that. It's written into the very fabric of the Constitution. Still in the Constitution today, for example, you find Section 25, which is headed Races Disqualified from Voting. It was put there in 1901 so that the states could stop particular races from voting. It's never been removed, and we still have this really odious provision within our Constitution. We've also got the races power, which is in the Constitution to enable laws to be made on the basis of race in order that those people, because of their race, can be discriminated against. And our first Prime Minister, Sir Edmund Barton, actually said about the races power, it's there, and I quote, to regulate the affairs of the people of coloured or inferior races who are in the Commonwealth. This provision is still in our Constitution. If you want to ask how is it that Australia could twice suspend the Racial Discrimination Act in recent times, it's because the Constitution doesn't just permit it, it was drafted to enable that to occur. And we as a country have never fixed that problem. Those provisions remain. Fortunately, we do have the prospect of a referendum on these issues. The Gillard government will, it seems, hold a referendum in 2013 with the possibility of changing the Constitution. And there's a lot of pressure for that referendum to deal with matters of symbolism, to put a fine set of words at the beginning of the document. And my own view is that we should have those fine words, but they will ring hollow without other words that actually remove the possibility of discrimination. The government's panel will report on these matters in December, and that will set the terms of the coming referendum. My own strong view is that we need recognition of Aboriginal and Torres Strait Islanders, twinned with, finally, the removal of the provisions that have enabled discrimination against them. We need to remove this Section 25, headed Races Disqualified from Voting, and we need to replace the races power with a provision to make positive laws for Aboriginal and Torres Strait Islanders. And I think in particular we finally need to overcome these echoes of the White Australia policy and actually put in our Constitution that says none of our laws may discriminate on the basis of race. Unless we do that as a society, finally actually outlaw racial discrimination in our Constitution, we will have a system that always will permit that as a possibility, that will permit future abrogations of the Racial Discrimination Act. Now, to my mind, if you want to overcome the problems of discrimination against Aboriginal people and also perhaps assist some groups like asylum seekers, I think we do need a clear, powerful, direct statement in our Constitution that racial discrimination is prohibited. And that will have a dramatic and practical effect in areas like Aboriginal justice and actually doing things in areas such as mandatory sentencing, the intervention and other policies. And that, I think, is a goal that needs to be worked towards. That's a realistic, if difficult, goal, but that, in my mind, is the current frontier of improving the protection of human rights within the Australian legal system. I'll just finish on this note. We've had what has been a debate over a National Human Rights Act which has not succeeded, and I think also establishing some real problems at the political level in this country about the absence of leadership on human rights, and that's been particularly evident over asylum seekers and Aboriginal peoples in recent times. That, I think, demonstrates a lot of the problems within our system. We have a constitution that depends upon people doing the right thing, on conventions being observed, politicians obeying rules about human rights, but they're not hard rules. They're rules that you simply obey unless there's a political opportunity that suggests you do something different. I think that, to me, says that in Australia we need a constitution that actually has hard legal rules about human rights. We can't rely upon politicians doing the right thing. We actually need politicians who must operate in a system that requires them to do the right thing when it comes to things such as racial discrimination. There's an opportunity to fight that fight over the next couple of years, and I'll certainly be involved, and I hope you also will see it as an opportunity through the coming referendum to do something positive for Aboriginal people and the Australian people generally by seeking to ensure we have a legal document that we can be proud of, that not only recognises Aboriginal Australians but says discrimination against them is not something that we would see as a fair go. Thank you.
Thank you, George, and perfectly timed. There wasn't a need for a ping at all. So I now have pleasure to introduce you to Graeme Innes, and Graeme is going to be talking about an issue very close to my heart, and that's the issue of disability rights.
Thanks, Claire, and I begin by acknowledging the traditional owners of the land on which we meet this afternoon. Now, this session's been accredited for continuing legal education purposes, so let's cut straight to the quiz. How many times is disability mentioned, firstly, in the Universal Declaration of Human Rights? And in the 1966 Human Rights Covenants? Well, if you answered none, I'll sign your sheet now for the CLE points, because you already know what I want to say. But I hope you'll stay to hear me say it nonetheless. I'm pleased to participate in Amnesty International's 50th anniversary year conference. Amnesty does outstanding work to advance human rights around the world and to empower people to stand up against human rights abuses instead of just being bystanders. It's clearly true, as an example, that poverty is both a cause and a consequence of violations of human rights, and accordingly that the right to an adequate standard of living is core human rights business. Presentation of human rights as indivisible, rather than being divided up into different classes, is one of the great features of the Universal Declaration. You might be aware that Australia played a leading role in ensuring that the Universal Declaration wasn't restricted to recognising civil and political rights. By the time that the Human Rights Covenants were adopted in 1966, however, the rights recognised in 1948 as indivisible were well divided. Now, why does this matter? After all, pretty much all the rights listed in the Universal Declaration do appear in one or other of the covenants, or in both. Well, it matters because the division changes not just what rights we think about, but how we think about them. In the international arena, we've frequently seen an unholy sort of bargain, where Western governments get to regard economic and social rights as uneconomic and socialist, and non-Western governments get to regard civil and political rights as a Western imposition. Now, for rights classed as economic, social or cultural, the result often is for them to drop off the list altogether. The division into two categories reflects and reinforces views like this. Civil and political rights are essentially negative rights for citizens to be left alone by government. the main mechanism considered for achieving civil and political rights is the method of judicial review. On the other hand, economic, social and cultural rights are essentially aspirational in character and considered as political claims rather than as legally enforceable or justiciable rights. Civil and political rights are thought of as being about laws, striking them down or at most making them, while economic, social and cultural rights are thought of as involving money and policy. Now, it's easy to accept these sorts of distinctions, but a quick look through the covenants and a moment's thought shows that these distinctions don't hold much water. One of the major obligations that attaches to each of the rights recognised in the Economic, Social and Cultural Covenant is the obligation to ensure that the right can be exercised without discrimination. And of course, discrimination is obviously capable of being made the subject of laws which provide for justiciable rights. These points have been made for a while now in human rights discussion to defend the view that economic, social and cultural rights too are real rights. But there's at least as great a need to think again about how we look at civil and political rights. The negative model of civil and political rights has been caricatured, not all that unfairly really, as representing the worldview of a white middle-class man who doesn't have a disability. As long as I can sit in my study and read, without the police being able to break in to ask what I'm reading, and as long as the law can't allow them to break in, at least without a warrant, things are basically okay. Amnesty's experience, and the experience of vulnerable people prioritised in Amnesty's work, goes far beyond the limits of that sort of worldview. Much of the violence against women around the world happens in their own homes, or in places they have to call home. And for refugees, the whole point is that their homes aren't safe anymore and they need to seek a new one. So I applaud Amnesty for seeking to protect human rights as they are experienced in the real world today, and not just in the basically okay world of our notional white middle-class male 18th century lawyer. Now I want to give some emphasis this afternoon to disability as an essential part of engaging with that real world. The Universal Declaration and the Twin Covenants require that the rights are recognised, be accorded to all persons without distinction or without discrimination of any kind. Full marks for universality there, except that they go on, in familiar United Nations style, to provide long lists of impermissible grounds for discrimination, and disability is not on those lists. I still find it hard to explain that omission, given that the Universal Declaration was developed in response to barbarous acts which have outraged the conscience of mankind, and that in Hitler's Germany, having a disability definitely did qualify people for some other lists, including for being put on trains to the extermination camps. But in the instruments of 1948 and 1966, all we have is a reference to other status. And as most philosophy students, or any member of a marginalised section of the community could tell you, having to wear the status of other is not the most empowering or inclusive experience. It's one thing to say that disability is covered legally this way, but clearly instruments which don't even mention disability are hardly the last word in doing something useful to protect, promote and fulfil human rights for people with disability. It's been too easy to regard rights in the economic, social and cultural covenants as aspirational statements at best, rather than as real rights with real implementation obligations attached to them. The rights in the ICCPR are clearly real rights, but there hasn't been a comprehensive implementation strategy here either. The first Human Rights Convention of the 21st century, the Disability Convention, has the merit of actually mentioning disability. But it also makes much clearer, compared to previous human rights instruments, that a national implementation strategy is indeed required. And it goes further, setting out the sort of measures that need to be taken. Perhaps it's for this reason that despite being one of the newest human rights instruments, the Disability Convention was the first one in Australia to have at least the beginnings of a comprehensive implementation strategy put in place, with the endorsement of the National Disability Strategy by COAG earlier this year. Now I say the beginnings because the strategy explicitly provides only a high-level framework, with detailed implementation plans due to come back to COAG early in 2012. and I urge Amnesty and all of you to keep a close watch on this process. The human rights community has pointed out that the ICCPR in fact requires remedies to be available for violations, hence the continuing campaign for a Charter of Rights, which, as you know, the Australian Human Rights Commission supported and continues to support. But state obligations under the ICCPR aren't confined to passing a law to provide for legal remedies for violations. Parties undertake to adopt the measures necessary to give effect to the rights recognised. And yes, it's time for my favourite human rights quote again. The great French jurist René Cassin said during the drafting of the Universal Declaration, "It would be deceiving the peoples of the world to let them think that a legal provision was all that was required, when in fact an entire social structure had to be transformed." Now, successive Australian governments, to their credit, have given this point some attention in developing and applying the concept of a National Human Rights Action Plan, which seeks to take human rights beyond the world of purely legislative measures and into broader public policy commitments and strategies. Australia's first two action plans were disappointingly limited in their ambition and effect, but I'm quite positive about the process that the Attorney-General's Department is conducting now for development of a new action plan. I know that Amnesty and others have been contributing actively to the process so far, and I look forward to that continuing. What I emphasise here, though, is how much need there is for urgent action to put an end to violations of the human rights of people with disability in Australia. We accept that it takes time, decades even, to change inaccessible environments like buildings or transport systems, and that it takes time to remove exclusion and discrimination in education. The US Supreme Court famously required school desegregation to happen, quote, with all deliberate speed, unquote. What's harder to accept, though, is that over the 30 years since Australia ratified the ICCPR, many people with disability face grave dangers of the rights that it recognises. Not as a matter of the threat of infringing laws being introduced, which need to be stopped. Not even mainly as a matter of existing laws, which need review, but as a matter of daily experience. And these include civil and political rights, which have been at the core of Amnesty's mission from the beginning. Freedom from arbitrary detention, freedom from cruel, inhuman and degrading treatment, and bodily integrity. It's over 2 years since I helped launch the Rights Denied report, funded by the New South Wales Law Foundation, which set out steps towards a national agenda on abuse, neglect and exploitation of people with cognitive disabilities in Australia. There are some very important recommendations in this report, which I hope will be picked up in the new National Human Rights Action Plan and the implementation plans being developed under the National Disability Strategy. Equally important is the highlighting of disability issues as serious human rights issues. The human rights community and the Human Rights Commission have rightly campaigned for a change in the situation where thousands of asylum seekers spend years in immigration detention instead of being able to live in and contribute to the community. The number of people who have no choice about where and with whom they live and who cannot participate in and contribute to community life because of that other status of disability is many times larger than the number of asylum seekers. The number of people with cognitive or psychosocial disabilities in our prisons is well in excess of their representation in the community, to the extent that we should recognise that prisons are currently a major form of the accommodation options that our community provides for people with disability. In many cases, these are people who've either completed their sentence or not been sentenced at all because of unfitness for trial, but who become and remain imprisoned anyway for lack of other more appropriate options. Of course, this has an even more pronounced impact on Aboriginal people, given the disproportionate rates of disability in Aboriginal communities and the lack of options and support in remote areas. Women and girls with intellectual disabilities continue to be subjected to violation of the right to bodily integrity through medically unnecessary sterilising surgery, very often due to a lack of sufficient supports being provided to enable families to take other options. As pointed out by the Productivity Commission's excellent report on a national disability insurance scheme, there are people with disability today in Australia who have to wear a nappy and get no significant social interaction in a 3-month period because of lack of resources to meet reasonable personal care needs, otherwise known as poverty. And if that's not degrading treatment, please tell me what is. And this in a rich country where people on twice the average income are being told by the media and some of our political leaders to feel hard done by. People in the disability community are used to the language and too often the reality of all this as abuse, neglect and exploitation. It's been so familiar that it's often almost accepted as inevitable. But people in the disability community are looking for this to stop. Looking, in fact, for what Peter Benenson would have called an amnesty. Let's join together to make this amnesty happen. Thanks for the chance to speak with you.
Thank you, Graeme, for so eloquently reminding us that equal rights are for all. I now like to invite Stephen, who's going to challenge us on the issue of enforcement. Thank you, Stephen.
Thanks, Claire. Hello, everybody. I'd like to also acknowledge the traditional owners of the land on which we meet and pay homage to those elders who are amongst us. It's my idea that enforcement was probably something good to talk about was actually reinforced in the workshop which I've just come from, where a Kurdish Australian called Fazil said that in many parts of the Middle East, especially amongst his people, it's thought that all of the human rights instruments in the world aren't worth 2 barrels of oil. I'm actually glad he said 2 barrels of oil, because when he was halfway through the sentence I thought he was going to say something much more obscene. But it does raise the importance of enforcement as a topic of discussion whenever we come to human rights protection consideration. I'm going to discuss it in 3 separate areas. I wanted to talk about what I call hard enforcement, and that's dealing with serious breaches of international law where you kill and do other bad things to lots and lots of people, things like war crimes and crimes against humanity. Then I wanted to talk about what I call soft enforcement, and that's the more general attempt to enforce ordinary obligations under international law and human rights instruments. I come into the area that Graeme discussed a little bit, because I did want to talk a little bit in particular about enforcement of economic, social and cultural rights. So starting with the serious breaches, I think it's important to make the point that nation states still act first and foremost on the principle of self-interest. The United Nations structures favour the powerful and the friends of the powerful and those whom the powerful need a vote from at some stage or other. It's only when you lose all your friends that you are subject to accountability for serious international crimes. Accordingly, we've seen strong international support for accountability for war crimes committed in the former Yugoslavia, because that state collapsed, and so there were no votes at stake on other key issues to prevent the alleged war criminals from being brought to account, and many of them have been. Similarly, the fragmented state of many African countries has meant that similar accountability has been brought to bear in Rwanda, the Ivory Coast and other countries, particularly in West Africa. On the other hand, there are at the moment credible allegations of war crimes committed during 2009 and early to mid-2010 during the Sri Lankan Civil War, and committed by both sides. There's the history of war crimes in Myanmar or Burma, which is both long and far from pretty. But even in the respect of those 2 countries, who aren't particularly blessed with friends, even when countries in the West decide it's proper to put on pressure for accountability, the People's Republic of China and many smaller countries are prepared to side with the Sri Lankan and Myanmar governments to keep any form of accountability or inquiry at bay. I think notwithstanding these deficiencies and criticisms, which are themselves substantial, I think the progress in terms of enforceability for serious international crimes has been significant. I think the establishment of first the ad hoc tribunals for the former Yugoslavia and Rwanda, and then the establishment of the ICC and the resourcing of that whole process has been commendable. I think the referral of Libyan crimes or alleged Libyan war crimes at an early stage to the ICC was also a recognition of the legitimacy of international accountability, even by countries like the US that do not recognise it for their own citizens. However, the ICC desperately needs to be seen exercising its jurisdiction with regard to some defendants who are not friendless black Africans sometime in the future. Another important matter for the ICC is the proper resourcing of defence lawyers and the proper separation between the administration of the prosecution and the administration of the court itself. International accountability will only work if it continues to be seen as impeccably fair. So that's what I wanted to say about enforcement with regard to serious international crimes. I wanted to move to what I call soft enforcement, which is enforcement of the more ordinary obligations under human rights instruments. Now, we do well to remember that the two broad-reaching human rights instruments which create binding obligations, the ICCPR and the ESCR, were only opened for signature in 1966 and only came into force in 1976, which I think is less than 4 decades ago. The extent to which they are accepted as standards, even when honoured in the breach, is a pretty significant achievement by NGOs like Amnesty that have promoted their status over that time. On the other hand, the enforcement processes that we have at the moment, that do exist, many of us might feel excused for not knowing that any did, they still feel less than effective. What happens often is that we all go through a charade of consultation, and at the end of that process one wonders how much notice any of the governments take and how serious governments are about trying to comply when any degree of political or policy difficulty is involved in complying. A recent example of that for NGOs and people in Australia is the Universal Periodic Review process that reached its climax earlier this year. It was a great event. All the interested NGOs dutifully attended meetings and the public servants looked suitably appreciative. In the end, the government's responses have been pretty disappointing and certainly appear to be driven by political expediency. I get the Attorney-General's press releases by email, and I get lots of them about cybercrime and the latest boat to have arrived. But I think on my observation, the Attorney-General only issued one press release on the UPR process during all of that time, and that was when the meetings were about to take place in Geneva, and whoever was attending on behalf of the government would look statesmanlike. It appears to me as if the government wants the NGOs to feel appreciated, but wants the general public not to take any notice of the process at all. These soft enforcement processes are being worked on. There is a Dublin statement, for example, on the process of strengthening treaty bodies. The treaty bodies are the United Nations committees responsible for the different committees. NGOs have responded with suggestions of their own on how this kind of soft enforcement can be improved, and that process is still continuing. One way of making treaties more influential is to continue the education and promotion process. Obligations are obviously more difficult to ignore if large sections of the general public are aware of the obligations and the rationale on which they are based. For example, Amnesty, I think, has made the adoption of the Declaration on the Rights of Indigenous Peoples and its endorsement by Australia in April 2009 a more significant event than it might otherwise have been, because there has been a strong campaign promoting its terms, particularly among the Australians with an Aboriginal or Torres Strait heritage who stand to benefit if the treaty is taken seriously. So that's what I wanted to say with regard to soft enforcement of these more general obligations, but you can see that that's going to continue to be an important challenge as this century continues to unfold. The third area I wanted to talk about was enforcement in the area of economic, social and cultural rights. And I think I mentioned it earlier, some of the issues that I wanted to touch upon include some of those issues that Graeme raised. I think if we differ on any important points, I defer to his greater knowledge and expertise in the area, so don't beat me up afterwards, Graeme, if I get any of it wrong. But on this area, there is a growing realisation, I think, that economic, social and cultural rights deserve at least as much attention as civil and political rights. And I endorse what Graeme said about by dividing them, we do think about them differently, and that's probably not an advantage for either set of rights. Certainly, we can't deny the importance of ESC rights, and I think this point has been made in a number of aphorisms over the years, but the absence of good health and access to treatment make the freedom, having perfect freedom of speech, fairly academic in many circumstances. But I think it is true that ESC rights raise enforcement and policy issues that are quite different to some of those raised by civil and political rights. For example, if your government does have a policy of torturing most arrested persons, in one sense it's fairly easy to solve that by no longer torturing those people. On the other hand, if women with a disability are severely disadvantaged in areas of health and education, the solutions are more complicated than simply building more schools and hospitals. And even that simplistic response may be difficult to achieve in a country where resources for public infrastructure are severely stretched. I'm not talking about Australia when I say that. In the same way, the right to work has particular policy difficulties as the vagaries of the international economic system buffet countries both large and small. The obligation on the country under Article 2 of the International Covenant on Economic, Civil and Cultural Rights is to take steps to the maximum of its available resources with a view to achieving progressively the full realisation of the rights recognised in the Covenant. This involves both strictness and leeway. It is strict in that it requires a maximum commitment of resources. On the other hand, only progressive realisation is demanded. However, many enforcement questions are raised by that phraseology. How much expenditure on defence at the neglect of other policy areas is too much? How much corruption in a particular country is permissible before you breach Article 2? How many tax deductions may rich countries give to their richest citizens and still cry poor about resources before breaching Article 2? Equally difficult, I think, is the notion of progressive realisation. Some aspects of chronic disadvantage are so profound that generations of good policy and commitment of resources may be needed to overcome them. On the other hand, progressive realisation may be used as an excuse to do nothing, or to do nothing that is either politically difficult or politically effective. For Australia, these questions are going to become increasingly important. What are we doing? What will we do in each case to address pockets of disadvantage? How many resources are we going to continue to throw at rich schools, for example? Are we going to give in to the proprietors of poker machines so that problem gambling can cause us to take several steps backward for every step we take forward? What other politically difficult changes do we have to effect to assist disadvantaged communities who, and I think this is important in the political equation, have little or no political power to bring to bear, either to promote their own rights or to bring to our political defence when we go out on a limb to assist them? To what extent will our obligations to report to treaty committees and special rapporteurs under various treaties affect the domestic politics that bear on these issues? And that's where the enforcement question comes in from the international point of view. And also, what advantage can NGOs like Amnesty and ALHR take of the fact that these are international obligations under the treaties? What can be achieved to empower those persons who have continued to miss out on important ESC rights like education, health and employment? I think they're really important questions. They raise policy issues, they raise resources issues, they raise philosophical issues, and they raise legal issues. And I think they're worth thinking about. Thank you very much.
Thank you, Stephen. And our final speaker this afternoon before we open up to questions is Widney, who is going to excite us, I've no doubt, about globalisation and the opportunities that technology offers us.
Good afternoon. Is everybody awake? Good. Okay. I want to again acknowledge the traditional owners and guardians of the land here. The core value that Amnesty International started out with was the idea that if you speak out, and particularly if you speak out to challenge those in power, you should not be punished, and you certainly shouldn't be thrown into a prison. From that idea, though, what I want to think about today is how much our ability to communicate, both to express opinions, to speak truth to power, and our ability to get and receive information that allows us to effectively challenge power is controlled by technology. Now, this isn't a new idea. I mean, when you think about it, I'm sure that when the Gutenberg press came into being, whoever was in power back then, I'm not quite good with my history there, was pretty nervous at the idea that somebody could start cranking out pamphlets and distribute it to 100 people as opposed to have a scribe do something and distribute it to 10. And the evolution of technology has influenced our ability to communicate throughout the decades. Now, one interesting element of the human rights law is that it actually says in the Covenant on Economic, Social, and Cultural Rights that all people should benefit from scientific and technological advances. But it's one of the least developed areas of human rights law, and it's one that has huge significance for us on a whole range of issues. One that I'll just mention but not go into is actually who owns the intellectual property with which you make vaccines if you're facing something like an epidemic that's global in nature. Okay, I'll just leave that hanging there. Okay, so now I want to talk about what's been happening now in terms of technology, communication, and right to information. We all know that when the uprisings happened, the revolutions in the Middle East, people talked a lot about technology, and I want to be absolutely clear here. What happened in the Middle East was because of the courage of people who took to the streets and defied the dictators there and said, enough is enough and you've got to step down because we want a revolution where people's wants are respected and where they can live free from fear. That being said, technology was an element of their ability to communicate and organize. And what we actually have here now with modern forms of technology is the ability to communicate in almost real instantaneous times, not just within a house, within a community, within a country, but even across borders. And that ability to communicate information in real time makes a huge difference. Somebody asked this morning about the Wall Street protest. Well, of course, I'm following this avidly too as a New Yorker, and the police keep saying 500 or so motley protesters. And yet every day I'm getting emails into my personal account that are showing satellite photos where Wall Street is jam-packed. In Wall Street, it takes a lot more than 500 people to jam-pack Wall Street. And those satellite photos are presumably in real time, and it's the ability to immediately challenge the assessment by the police that it's a mere 500 motley people who don't have a job to go to. Also with technology, we see the ability to share information. Now, if anything, most of us suffer these days from information overload. How many have so many emails coming into their inbox they have no idea which ones to open and which to just delete instantaneously? Our ability to cipher through, to go through the information that pours in on us is a challenge for us. But the point is that we have access to that information. And again, we're getting it often in real time in a way that allows us to more immediately challenge things that are happening. The other thing that I think was particularly critical in talking about technology's roles in the sort of protests that we're seeing from Wall Street to Madison, Wisconsin, to Syria, to China, and all the other places that we're seeing people say enough is enough, is the ability to organize, again, through technology that allows you to communicate immediately. So whether we're talking about flash mobs for fun or using the same technology to say we are going to all meet in front of the headquarters of the Muhabarat and protest today at 3 o'clock, it's an incredibly powerful tool for us. And the last element I want to point out to is the solidarity. Now, I think that when the protesters took to the streets in Tunisia and in Egypt, the solidarity that meant the most to them was actually the communication they got from other people in the region. It was that sense that somehow or the other, people living under comparably repressive regimes were able to see and support each other, knowing exactly what it meant, which is a very different type of support than what they may have gotten from other parts of the world. But in talking about technology, I think it's critically important that, one, we recognize that there's nothing deterministic about technology. Technology is not inherently pro-human rights or anti-human rights. It is actually neutral, and it depends on how it's being used and who controls it. And that, I think, is one of the biggest challenges that we face going forward. Right now, technology is making the world a little flatter for us. The ability of governments to control technology, to surveil its citizens, to gag them, to feed them disinformation, is being challenged by the rapidity with which technological advances are happening. But let's be clear, all those governments are busy with their top engineers trying to figure out how to regain control of that technology so that they can go back to monitoring communication, controlling who has access to information, and shutting down the ways that activists will and do use these communications technologies for organizing and for solidarity and for sharing communication. And the challenge for us is how we make sure that we keep the realm of freedom of expression and the right to information as government-controlled free as possible. And it is a challenge that we've been facing for decades. Again, this is not new. When governments in Central Asia want to stop media freedoms, what they do is they raise the price of paper, they shut off electricity to the printing press. This is not new what's happening, but the challenge for us is to make sure that we basically work with technology companies to emphasize to them that they must not become complicit in human rights violations by governments. Again, when people were taking to Tahrir Square, Mubarak ordered Vodafone to pull the plug on mobile communications because he knew people were using SMS and text messaging to figure out how to organize. Vodafone pulled the plug. Vodafone is a corporation that had no right to pull the plug on people's ability to communicate. And yet, when we challenged Vodafone, they came up with a duplicitous explanation and now are running ads where they take credit for the Egyptian revolution. We need to communicate to the technology companies, whether it's Facebook or Google or Twitter or whatever the new versions of these are going to be. You have chosen as your business plan to enter a realm of rights, freedom of communication and freedom of information, and you must not become a tool of the government in oppressing people. You must challenge the government and you must build redundancies into your system so that you cannot be used by governments in this way. Just two more points I want to make, and then I'll be quiet. One that is a challenge for us is what we're seeing in the digital world is largely a gender divide. In a couple weeks, I'm going to speak to a bunch of the executives in Silicon Valley, and I looked at the list of people who are organizing and are going to be at this conference, and it's all guys. Seriously. I think I may be the only woman speaker, and I may be one of, I don't know, I think I'm going to be massively underrepresented there. It is a world of men. Now, that doesn't mean that women haven't used it. If you look at what women have done with cell phone technology in developing countries, it's actually quite amazing. They've taken small loans bought cell phones and turned it into a business for communication. It's not that women aren't smart enough, and it's not that they don't know how to use technology, but their access to that technology in many ways is limited, and I worry that there's the possibility of creating a gender divide in which men will have access to these technologies and all that implies, and women will be left behind. Parallel to that, or very much hand in hand to it, is the question of digital technologies and what it means for people in the economic divide. Again, cell phone technology has been one of the most critical tools of activism in developing countries, but access to many other, the devices that you and I probably take for granted, that we carry a laptop now in our pocket for all intent and purposes, is largely not available in the developing world. And what does that mean in terms of the ability of people to share, again, quoting the Covenant, the advantages of scientific and technological advances? Thank you.
Thank you, Widney. I hope everyone agrees it's been a really stimulating discussion by the four speakers. George kicked us off beautifully, talking about values and fairness. He reminded us that Australia is not the lucky country for all. It's certainly not the lucky country for our First Peoples or for people seeking asylum, but that we do have an opportunity with the Constitution, and that the referendum gives us that opportunity, and it gives us an opportunity particularly for ensuring that the First Peoples of Australia get their true recognition. We then had Graeme, who really kind of gave us a bit of a challenge, I think, in terms of how we are going to transform society. There's probably more than a 3-day conference in that statement there, but it's something that we all have to think about, because as we speak, as Graeme so well reminded us, there are people with disabilities who are imprisoned here in Australia. They're imprisoned not by their disability but by society, and they're facing abuse, neglect, mistreatment and exploitation. And then Stephen, he also kind of reminded us of the good and the bad, really. The bad is that he reminded us that nation states act in self-interest, and it's only that when they lose friends that they're held to account. But the flip side of that is he reminded us of the real progress in enforcement, particularly in relation to the International Criminal Court. And then we just heard from Widney, who told us about the amazing people in the Middle East and North Africa and their huge courage, where they battled tanks and they battled bullets, and they were armed with mobile phones and blogs. But she also reminded us that technology is human rights neutral, and it depends on who controls it and who uses it the best. And I know that in this room there are incredibly talented individuals who are already using new technology to improve human rights, and that's something that we need to continue. So I'm now going to open up to questions. We've got about 22 minutes, and I already have a hand up over here on the front row. Thank you, Dan.
Thanks. My name's Anna. I first joined Amnesty over 20 years ago when I was at school, but the reason I'm actually here is because I'm lucky enough to work in the office of Kelly Vincent, who is she's still out of the room, I think, dealing with some issues relating to a rally in South Australia tomorrow. For those of you that don't know, Kelly Vincent is she's the youngest female parliamentarian in Australia, and the first woman elected, or the first person elected to the South Australian Parliament that uses a wheelchair for mobility, and the first person elected on a disability platform to any Australian Parliament. And I'm very lucky to have started working for Kelly a month ago, and I've worked in the area of social justice and politics and community activism for a number of years. but I am shocked at some of the issues that we deal with in our office on a daily basis relating to disability, and I would echo Graeme's points made. The issues that he raised, we deal with in our office every day, to do with young women that are having their bodily integrity taken away from them, children that don't see their rights realised in any way. And I'll give you an idea of some of the issues we're facing in South Australia at the moment. And I guess this question, well, the question at the end of it would be more posed at all of you, but more at Graeme, because it strikes me that disability isn't a very sexy human rights issue. Asylum seekers and so on, are, and I think I've been guilty of this over the years as well. But in South Australia at the moment, we are dealing with an issue relating to alleged sexual abuse of children with an intellectual disability. And those of you that would have seen Four Corners 10 days ago, this issue over a 30-year period in South Australia was covered. But we have an education minister that says it's, in terms of putting cameras and so on school buses is a big challenge. We have the Chief Justice saying allowing evidence to be heard in court from people, from children with a disability and people with an intellectual disability that can't communicate well is just too hard an issue. So we have charges being dropped against alleged perpetrators of sexual abuse and abuse of children in South Australia purely because the police say they can't prosecute because evidence can't be heard. And then a legal system that says it's too hard to figure out a way to change this. So I guess my question to you, Graeme, is how do we overcome and get the greater will there from government and even the legal system to come to the party on this, because it's a big barrier we're facing at the moment.
Well, it is, and I'm not sure that I can add too much to what I've already said and the statements that you've made, except a couple of things briefly. Firstly, Claire is absolutely right. I am issuing a challenge to Amnesty and to human rights practitioners throughout Australia to recognise that human rights are for everyone, and that whilst in no way do I want to diminish our efforts in other areas, I think we do need to have more of a focus on the 20% of Australians with a disability. Let me add one more example to yours, Anna. I think you said, I hadn't realised Kelly was here today. I must catch up with her later on. But let me add one more example to that, and that is this. 3 of our airlines, Virgin, Jetstar, and what's the one that stopped flying for a while? Tiger, thank you. Have a policy which is known in the disability field as the 2 wheelchair policy. That means that whether or not you've told the airline that you use a wheelchair, you can turn up at the airport, and if you're the 3rd person in a wheelchair, you don't get on the flight. Now, show me a better example of discrimination and apartheid than that right here in Australia. This happened to 2 women in flying back with MS, flying back from Adelaide to Melbourne a few weeks ago. They rocked up at the airport having told the airline, and they said, oh, sorry, there's someone with a wheelchair on board, so only one of you can fly. Effectively, the 2 of you can't fly. I got really angry. I'm a fairly calm person. I'm passionate, but I'm fairly calm. It was a Friday afternoon. I got really angry, and I thought, I'm going to have to channel this anger somehow, because if I don't, I'm going straight home and the white wine supply is going to get hammered. So I sat down and wrote an op-ed, and it was in a humorous vein about this, saying, well, if we can only have 2 wheelchairs, let's only have 2 babies because they cry all the time, and let's only have 2 flight attendants because they just go up and down the aisles with trolleys and try and sell us stuff, and let's only have 2 air safety, 2 in-flight announcements, and let's only have 2 politicians because they've got a lot of baggage, and and let's only have 2 airline executives because, I won't go into the details. Anyway, I couldn't get this to run in any mainstream media. Finally, it was published on ABC Ramp Up, the disability portal, of course, to a whole lot of people with disability who already know the story and and who I don't need to get to. So we as a society have a big problem because we don't recognise the issues facing people with disability. And I'm very keen and calling on human rights practitioners around Australia to join with the disability sector to start to turn this around.
Thanks, Graeme. There's a question in the middle here.
I'd like to direct this primarily to George and Stephen because of the constitutional and the civil rights overtones, but not exclusively so. I'd like you to help me deal with a word that I just find extremely troublesome, and it's been used a few times today, and sometimes in more than one sense. It's the word race. I'm never quite sure what to do with that. I had a high school group in Amnesty a few years ago, and I said, what do you make of the word race? And the more we got into it, the more the waters just got muddied and muddied. And in the end, somebody jumped up and said, there's really only one race, it's the human race. And then I said, well, if there's only one race and it's the human race, do we need the word race to go with human? Because when you talk about the Constitution, when you talk about civil rights, are you talking about colour? Are you talking about blood? You know, somebody's got Aboriginal blood. Are you talking about nationality? Somebody tried to put an Aryan race on us. Are you talking about religion? The Jewish race. Are you talking about ethnicity or cultural background? When I was a little kid at Bulimba State School, I was sitting down at little lunch with two kids, and one said to the other, I'm white. And the other said, well, what am I? And he said, you're half-caste. And I walked up to one who said he was white with a white sheet of paper, and I said, you're not white either. And the other kid went home and said, Mum, what caste is Dad and what caste is Mum? Neither of them were Indian, but they get the label half-caste pinned on them. Will somebody explain to me what Caucasian means? I think it might have been Stephen, who, for his specific purposes, so it was quite justified, talked about black Africans. Is there a tautology in there somewhere? Because if you talk about an African American, it becomes more apparent what Africa means. Somebody I heard use the word pygmy race. We use indigenous almost as though it's synonymous with race at times. I wonder whether the word race, rather than grouping us to categorise us, ultimately divides us. And if you're going to be talking about reconstituting the Constitution, I wonder whether we can find better words that do the job for us than words like race, which I think have all sorts of insidious overtones.
Look, thank you for that very thoughtful question. And the reason we use the word race in our Constitution is because race was the way people were divided back in the 1890s, more than 100 years ago. It was the tool that was used to discriminate, to divide, and that found its way and is still in our Constitution. So we're talking about race today because our foundational legal document still has those classifications in it. And that said, I agree strongly with you that it's a concept that just doesn't work in this legal setting, with one exception. And that's because it's based on a discredited scientific theory, if nothing else. And this whole idea of dividing people up based upon these biological differences just doesn't work. I mean, it's been scientifically disproven, yet we have this scientifically disproven theory at the heart of our Constitution as a basis upon which this discrimination can occur. That's the problem. My own view is we remove all references to race with one exception, and that is put something in that says no laws can in the future be made that allow that type of differentiation. So you prevent it occurring and you say it's not to be used. I think if you don't do that, you run the risk that it will be used. Silence amounts to permission in these contexts. So I'd be using it in entirely a way to prevent its use, and otherwise it has no place in our Constitution. And when it comes to recognising Aboriginal and Torres Strait Islander peoples, peoples is the appropriate word, and we recognise them as the first peoples who inhabited this continent. It's not because of their race or their biology, but it's because of their status and their unique place on this continent, and that I think is the appropriate way of approaching that issue.
I just think it does raise a couple of complex issues. I mean, I often think about us in genetic terms, because I actually think that the period of time since we ceased to be people living in small villages, mainly hunting and gathering, everything bad about me I can explain by reference to what I needed to be adapted to that kind of lifestyle. But I think racial discrimination is only one aspect of what we do, which is to find ways in which we can identify with those people who we call us, and that nearly always has a dark, ugly side, which means that those people who aren't us, in fact, I think John Howard used the subtleties of this very well a couple of years ago. But you know, we divide on the basis of ethnic. We also divide on the basis of which football team we support. I mean, religious differences have caused people to kill each other over thousands and thousands of years. So it does, in a way, come back to our nature that, and we identify discrimination, and then in order to outlaw it, we have to identify some of that source of, or the reason why people are being discriminated against in the first instance. I don't think any of that made any sense, so I'll go on. The other, I think, interesting notion is visibility and invisibility. And I think Graeme might have something to say about this for more than the obvious reasons, but often people of a particular race or disadvantaged in some other way, often they become very visible to us in the sense of if a Kurdish person is arrested and appears in court and is reported in the newspaper, we think only Kurdish people do break in and enters, whereas if a Caucasian person, and there's thousands of them being charged with criminal offences all the time, we miss that. So people of a minority group become visible to us. And at other times, disadvantaged groups, and I think people with a disability fall into this category, often we just don't see them. They disappear from our consciousness, they disappear from our recognition. And in one sense, we've struggled, for example, with what to call people with a disability and how to refer to it, because in a sense, to use any phraseology becomes discriminatory. But you have to use a phraseology because you've got to counter the invisibility of the issue and the discrimination that's going on at the time. So I think there's a whole lot of very complicated psychological issues that arise out of what you've raised. And as I said, I don't think anything I said made any sense, but there you go. It's my best effort.
That's good. I don't think I can say much there. I agree with what Stephen said.
Mary at the front's got a question, so better let her have a question. She's done a lot of hard work for nothing.
Thank
so
you. Stephen, no, everything you said did make a lot of sense, and I'd just like to explore that a little bit further, this notion of race, because it seems to me that we now have a global movement going of people who see themselves as global citizens rather than members of a particular race, primarily. That's the currency that we want to use to exchange with other people, not the fact that we're male or female, or that we're Greek or Italian or Indigenous, for that matter. The thing that counters that, though, the pushback, comes, I think, when people in that position are criticised for not being patriotic. So that's the big pushback. So there's a lot of pressure on people to continue to identify themselves according to their race. And I'm just wondering whether what you and perhaps other members of the committee think, of the panel think about the importance of all of us feeling first and foremost that we're global citizens, because after all, how are we going to solve these problems of people, where people can live, and how we're going to preserve the environment for future generations when we have to take into account national interests? We really do have to have an international outlook.
Thanks, Mary. I might ask Widney to kick off with that, because obviously being part of a global movement, it's something that we're very passionate about. Widney?
Gee, thanks. Well, I think first I just want to reinforce there's no genetic marker for race. Race is an absolute construct that's been imposed on us to make us see difference. That being said, I think it's incredibly important that the concept that I'm more comfortable with of ethnicity, that people can define their communities, their shared cultures, their languages in a way that allows them to preserve that without it being an us-them dynamic is really important. And usually I think that happens when the need to preserve is actually when you're under attack, because that culture, that language, that tradition is itself under attack. So I think that's just an important distinction to make. I would love it if we actually were a global race. I think the problem is, and this may be a rather unpopular thing to say, but I think that national pride has been exploited for the concept of the preservation of a nation state as opposed to the human security of the people that live within that state. And that because we then get identified according to a national identity, that becomes part of the contest in the power struggle. So if you look at, for instance, the impact that I mentioned this morning of globalization actually bringing many people out of poverty, but actually increasing disparities between the richest and poorest countries, where some of the poorest countries are the ones that are actually the most resource rich and wealthy. They're not poor, but the people in them are impoverished. But this sense that somehow or the other, that if your country is smart enough to get away with them being able to exploit natural resources and bring them home to your benefit, then you identify as a citizen of that nation that succeeds at exploitation at the remove of the people in a country who are being exploited. I do think that the way that this is going to have to be resolved at some point is there is a point that all of the human race's ability to survive is going to be challenged. Whether it's, water may be the reason why, simply access to water. And at what point do we decide that we're not going to save ourselves and our clique, but rather we're going to survive together, and in doing so, hopefully survive for future generations?
And if I can just add something there, which is kind of like Amnesty prides itself on outrage and hope, and that's probably, there's a bit of Widney's outrage, and I will add a little bit of hope. Widney and I have just been at a global Amnesty meeting, as well as a few others in this room. And what gives me great hope for a human race, which is a global race, it is at those types of global meetings. So you've got 130, 140 countries represented there. And yes, there are differences. Some play cricket and some have never heard of AFL. The Latin Americans don't come out till it gets dark, and the French go to bed early. But despite those differences, what brings us all together is a shared view of humanity, shared values, a shared passion for fairness, for equality, for dignity and justice. And when we come together and we share that and share that passion, that's what gives me the hope that actually we can find and implement global solutions. Russell in the middle. Russell and quick is an oxymoron, for those of you who know Russell.
The question is really in terms of, probably to everyone, perhaps Claire and Widney might want to excuse themselves, but it's really in terms of Australia. We've talked about, if you like, in some senses, the mainstream. We've talked about minorities, and I'm thinking about and George mentioned it earlier, about in a sense, trying to develop a human rights culture, or people's ignorance of their rights. And I'm wondering whether each of you, what you see as the role for Amnesty in Australia and perhaps as elsewhere, in terms of getting onto the second part of addressing the challenges and looking for the opportunities in trying to get the mainstream in the service of minorities, and What area in terms of either, I guess, respect, protect or fulfil? What area in respect of perhaps legal, policy or practice issues? If there was one thing you said Amnesty should, as a vehicle, do in relation to pushing forward, in relation to the challenges, what would it be?
Thanks, Russell. Stephen, start with you.
I think one of the challenges, the opportunity is that there are these human rights instruments which are legally binding, which provide common standards against which we can judge our policies, our laws, our performance. And I think the difference between 45 years ago, before they existed, is quite important. I think there's also, however, an issue that one has to explain the significance of human rights instruments and not just use them as a club to strike over the head of the other person in a political discourse. So one of the things I think that is important is not only to say this particular action is in breach of Article 21, but there needs to be at the same time that education and discussion going on about where the instruments come from, why they are important, why we adopted them, the fact that we adopted them, for example. I think whenever I use the word human rights in a press release, I say the obligations that Australia freely took upon itself, for example. So I think it's shaping the discourse in a way that is persuasive to a person who's not already into the human rights culture, because I do think there is a tendency that if you use it too much as a political club, you can tend to alienate people and do the whole cause of human rights protection a disservice.
Thanks, Stephen.
Look, I'll follow on from that quickly, and there's a lot I could say, but I think there's one thing that I think people who work in the field of human rights can do when it comes to language and talking to the broader community, and that thing I think starts with not using terms like minorities and majorities. I wouldn't get into that, but I actually think one thing that people interested in human rights need to do is reclaim the concept of responsibilities, which for most Australians actually has greater power than human rights. I've seen this on many, many occasions. There's a reluctance about human rights, but there's a quick embrace of responsibilities. And I think a debate that includes things like our responsibilities to asylum seekers, which we do have as a wealthy nation, our responsibilities when it comes to people in need, people with disabilities and others. I think there's a language shift there that we need to embrace, and if you like, more conservative people put responsibilities in opposition to human rights, but in fact they're two sides of the same coin, and I think there's a shift there that we need to make in our language that actually will make a lot of what we're talking about more accessible and frankly more palatable to the broader community in Australia.
Thanks, George. So as we contemplate being a human responsibility organisation, I'm just going to give the last word to Graeme, and we're out of time for questions, unfortunately.
Well, I mean, I've already, I think, had my go at this question, but I've never been backward in having two cracks where I can. I mean, I think that, that I won't go back over the challenge that I think I've given you, but the other thing that I would say is that you need to do what you're doing now, but continue to do it and do it more effectively. And I think that's two things. One is use social networks and social networking, really effective way. Widney talked a bit about it, and Amnesty does it. I follow you on Twitter and your various other areas. But the second thing about people aren't interested, and Commission's done some research on this. People are not interested in hearing about human rights instruments, as Stephen said. They're interested in hearing human rights stories. So keep telling stories.
Thank you, Graeme, and I will pass you back to Mary's capable hands.
Just while Mary's coming back, I'd just like to say that Andrew Bolt's now on board on the concept of freedom of speech, so we're obviously making progress.
Well, that was a terrific discussion. Thank you for all the questions, and please join me in thanking our terrific speakers. brings us to the end of today. Now, we've been talking about social media and IT, and I just want to know how many people have sent out a tweet today? Oh, yes! Fantastic. Great. Now, the one thing that I would like you to do when you tweet tomorrow or tweet after this session and during the conference is use #Amnesty HRC, Human Rights Conference, Amnesty HRC. So please keep tweeting, that's great. You're all going to come back, I hope, at 5 o'clock for the reception, and I'm sorry that I can't join you. And you've got a terrific couple of days to look forward to with more wonderful speakers. Tomorrow, Julian Burnside, Rabia Kadir, and many, many others. So do enjoy, and thank you. It's been a great joy for me to be with you here today. Thank you.